Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk, the most fact-based, unbiased, true crime channel on the entire internet. Now, first on the docket, once and for all, finally, I'm going to explain to everyone why Chris Watts is never getting out of prison and why he's never going to get a hearing to withdraw his guilty plea. Second, a mayor busted for DUI while sitting in the drive-thru at White Castle. And finally, our dumb criminal contestant of the day and a recap of the contestants for the crown of dumb criminal contestant of the week. Let's talk about it. Good day, Crime Talk aficionados. This is Crime Talk, and my name is Scott Reich. Thanks for watching. We know you have lots of choices out there. We appreciate the fact you took the time to watch me today. Now, if you haven't done so already, please hit that subscribe button and hit that little bell so that you receive notifications of when we go live or we put up new content. Now, first on the docket, I am going to explain in the most simplest of terms why Chris Watts is never getting out of prison and why he is never going to get a hearing to withdraw his guilty plea. The other day, while I was reviewing comments that were coming in, there was a string regarding Chris Watts and people that support Chris Watts. Okay, fine. If you think Chris Watts needs support, you think he needs change, do what you want to do. But guess what? He's never getting out of Dodge. He is never leaving prison, okay? Bottom line. Now, we've explained this before, but we want to do it again because apparently there are actually people that are professing theories that somehow Shanann Watts, obviously in an effort to frame Chris Watts, killed her children and then must have killed herself and thrown herself in a shallow grave simply to get Chris Watts, and he is an innocent man. All right, ladies and gentlemen, for the people who believe such nonsense, let's take a look at the transcript of the guilty plea. All right, for those of you who don't recall, this took place back on November 6th of 2018. It was a status conference at the request of both the prosecution and the defense, and they appeared before Judge Kopkow. Now, we've mentioned this before. The reason why the court engages in the colloquy that we're about to go through here is because you can't have people getting buyer's remorse and suddenly saying, ooh, I don't think I want to plead guilty anymore, okay? And once you're done with sentencing, it is nearly impossible. But let's take a look at it. On that date, the court said it is November 6, 2018. It's 2 p.m. and we're in Division 17 of the Weld County District Court. The court goes on and basically says why they are there and that the court identifies who all the attorneys are going to appear in this particular case. The court actually apologizes that the courtroom is not big enough and that everyone needs to keep their emotions in check because obviously this is a very emotional situation. Now the court on page 4 engages in the initial inquiry with Chris Watts. The court reviews the paperwork and the court then asks Mr. Watts, says, I'm going to discuss this paperwork with you. If at any time you have any questions, comments, concerns, it's very important that you let me know. Do you understand that? Chris Watts states in the affirmative. The court then goes on and details what he is going to plead guilty to. And I'm not going to go through all of that right now because when we get to the important part where the court actually reads the charge and there's a stipulation of a factual basis, it will all come very clear. The court then on page 5 further goes on to state that count 1 as it relates to the death of Shanann Watts, this is an act of domestic violence. The court further explains that all sentencing options are open with the court and that the sentences, some of them could run concurrently or consecutively, but that's completely up to the court. Mr. Watts was asked whether he completely understands that. He answers on page 6, line 1, Yes, sir. The court inquires, do you understand what the word consecutive means as opposed to concurrently? Mr. Watts, once again, page 6, line 5, yes, sir. Your lawyers explain that to you. Mr. Watts, page 6, line 7, yes, sir. The court further goes on, and this is important. Page 6, line 8. The plea paperwork continues to state that you will not be permitted to waive a factual basis for the charge. Do you understand that? Line 11, Mr. Watts, yes, sir. Why is that significant? The significance of that is because if you waive a factual basis, it's kind of your way of saying, I'm not saying there is, I'm not saying there isn't enough facts to support this case, but I'm kind of pleading guilty to get it over with. Here, the prosecution, knowing that this kind of gamesmanship would go on later with Mr. Watts, said, no, you and your attorneys have to stipulate, which means you agree that you were the one that committed the crime and that there is sufficient evidence to convict you of all charges. The court continues to go on. If Mr. Watts were to commit a new felony while in custody, they could withdraw from this plea. Kind of standard language, but no, not a big deal. The court then goes on, and I think this is one of the most important parts of the case, because the judge has to be able to understand and appreciate and make sure that the defendant understands and appreciate what is going on and that this is truly what he wants to do. So, page 7, do you have any questions about anything so far? Mr. Watts then says no. Can you tell me your highest level of education? Mr. Watts responds with technical college. The court, so you graduated from high school and then went to technical college. Mr. Watts, yes, sir. Do you have any difficulty reading and or understanding the English language? No, sir. Did you have an opportunity to review this written waiver and guilty plea? Yes, sir. There's then a brief discussion about having the prosecutor sign this paperwork as well, because there was the death penalty was being taken off the table. The court then continues. Now, the first 2 pages explain all of the rights that you have and the rights that you're giving up. Do you have any questions about those rights? No, sir. Any questions about the terms, concept, or definitions? No, sir. Did you have sufficient time to discuss these very important rights with your lawyers? Mr. Watts, yes, sir. Are you completely satisfied with the assistance of your attorneys? Yes, sir. Do you believe that you've spent sufficient time discussing the rights with them? Mr. Watts, yes, sir. Do you believe that you've discussed different strategies and defenses and gone over all of the discovery with them to your satisfaction? Mr. Watts responds on page 8, line 21, yes, sir. Did they answer all of your questions to your satisfaction? Yes, sir. To date, is there anything that you believe that they should have done that they have not done yet? Mr. Watts responds, page 9, line 3, no, sir. So again, you are completely satisfied with the assistance of your attorneys representing you in this case. Mr. Watts, yes, sir. Why is that significant? If Mr. Watts were to try to bring a 35C petition, you basically have to say that your counsel was ineffective. Boom, right there. The court made that absolutely bulletproof. That makes it so that there will never be a hearing as it relates to Chris Watts withdrawing his guilty plea. The court then goes on and says, do you have any questions about the definitions of the crime that you're pleading guilty to? Nope, none whatsoever. One of the definitions regarding domestic violence was not included. The court was going to advise him of it, and Mr. Watts says, no, sir, my lawyers went over that with me, clearly indicating that he has reviewed the paperwork, all the legal definitions, elements, and possible penalties completely with his attorneys. But yet the court goes through it yet again. The court goes on again regarding mandatory sentencing and explains that in regards to the unlawful termination of pregnancy in the first degree, a class 2 felony, that carries a prison sentence of 16 to 48 years confinement in the Colorado Department of Corrections. Do you understand that? The court also explains counts 1, 2, 3, 4, and 5, murder in the first degree. The minimum mandatory sentence that the court would be required to impose is life in prison without possibility of parole. Do you understand that, Mr. Watts? Yes, sir. The court goes on in regards to counts 7, 8, and 9, which are Class 3 felonies and carry a possible sentence in the Colorado Department of Corrections of 4 to 12 years. Mr. Watts says that he understands that as well. The fines are discussed, but no fines were imposed, so it really doesn't matter. The court then goes on page 13. Has anyone put any pressure on you or forced you or threatened you to do this? Mr. Watts, page 13, line 3, no, sir. Question by the court, are you doing this of your own free will? Page 13, line 6, yes, sir. The court then asks, do you have any questions that the court can answer for you with regard to the rights you have, the rights you're giving up, and the possible penalties, and what the plea agreement is in this case? Mr. Watts, no, sir. The court then says, knowing everything that we have discussed, I'm going to now individually ask how you wish to plead to each count. And then the court goes on to read from the charging document. Count 1 alleges murder in the first degree, a Class 1 felony. It alleges that an act of domestic violence on or about August 13th, 2018, Christopher Lee Watts unlawfully, feloniously, and after deliberation, and with the intent to cause the death of a person other than himself, caused the death of Shanann Watts in violation of 18.3.102, subsection 1A. How do you wish to plead to this count? Guilty. The court says, excuse me. Mr. Watts then says, guilty. Count 2 is related to the death of Bella Watts. How does he plead? Page 14, line 11, guilty. Count 3 relates to the death of Celeste Watts. How does Mr. Watts plead? Guilty. Count 4 alleges murder in the first degree, a Class 1 felony, alleges that between and including August 12, 2018 and August 13, 2018, Christopher Lee Watts unlawfully, which means without legal permission or justification, feloniously means it's a felony punishable by a possible sentence in the Colorado Department of Corrections, knowingly caused the death of Bella Watts, a child who had not yet attained the age of 12. How does he plead? Page 15, line 6, guilty. Count number 5 alleges murder in the first degree. Also alleges that Christopher Lee Watts unlawfully, feloniously caused the death of Celeste Watts, a child who had not attained the age of 12. Watts, guilty. Page 15, line 17. Unlawful termination of pregnancy, a Class 2 felony. Chris Watts enters his plea as to that count after being read in open court to him. He says, when asked by the court, how do you wish to plead to count number 6? Mr. Watts, guilty. Count 7 alleges tampering with a deceased human body, a Class 3 felony. And it alleges that Christopher Lee Watts, believing that an official proceeding was pending, in progress, or about to be instituted and acting without legal right or authority, unlawfully and feloniously, willfully destroyed, mutilated, concealed, removed, or altered a human body. How do you plead to count 7? Guilty. Count 8 alleges that believing that an official proceeding was pending, in progress, or about to be instituted, and acting without legal right or authority, unlawfully and feloniously destroyed, mutilated, concealed, removed, or altered human body parts, remains, with the intent to impair their appearance or availability for the official proceeding. The court then asks, how do you plead? Guilty. Count 9, tampering with deceased human body. How does Mr. Watts plead? Page 17, line 18, guilty. Then, most importantly, the counsel for Mr. Watts, when asked how they're going to proceed, whether Mr. Watts was going to explain himself what he did, his attorney chimes in and said, we would stipulate to the factual basis, Judge. That means that the facts in the allegation are all true. Chris Watts admitted through his attorney that they were all true. The court then goes on. So the court is going to accept your guilty pleas to count 1 through 9. The court finds that your guilty pleas are being entered knowingly, intelligently, involuntarily. And the court is going to have Mr. Watts held without bond being able to be posted. Now, what's the significance of the court making those findings? It means that the court was able to observe Mr. Watts, make sure that he was coherent, understood what was taking place, and that no one was pressuring him to do what he wanted to do. I'm telling you, guilty pleas, if the court notices any hint that somebody is not doing this knowingly and voluntarily, they will set the matter for trial and not accept the guilty pleas. That's why it's so important. That's why Chris Watts is never getting out. Now, if the guilty plea, the transcript of Chris Watts in court pleading guilty is not enough, go to the link below where you can see the interviews with Chris Watts, with the investigators from the FBI, CBI, and local authorities, and he explains what he did. He explains that he was happy with his attorneys. Mr. Watts is going nowhere. And if anyone thinks that they are somehow going to persuade a court to give Mr. Watts a hearing, these people are complete charlatans, and they are doing nothing but trying to get people and their money. Ignore it. I'm telling you, he's not going anywhere. Hopefully, once and for all, that will finally clear it up. And hopefully, this will spread like wildfire. And we will put this transcript up just so you think, hey, Scott, maybe you took something out of context. We will put this transcript up at ScottReisch.com, and you can see it there for your own eyes. Read it yourself. These are facts, ladies and gentlemen. This is not speculation. A quick recess. Ladies and gentlemen, please go to CrimeTalkSearch.com and sign up for your background subscription service. You can anonymously search as many people as you like when you sign up, and you're going to get a report while you wait. And in that report, you're going to get information related to social media related to the person you're searching about, phone numbers, emails, criminal history, property records, marital records, divorce records, everything you need to know about somebody if you are going to be involved with them or engage in some sort of business relationship with them. Please go to CrimeTalkSearch.com, sign up. You'll be glad that you did. Next on the docket, a mayor in Kentucky has been charged with DUI after she fell asleep in the drive-thru line at White Castle. Mayor Beverly Chester Burton was arrested after the police were dispatched to the White Castle, and according to the arrest affidavit, she was in a silver Cadillac smashed against a large utility pole with Chester Burton standing next to it. Witnesses approached the officers and told them that Chester Burton had been asleep in the White Castle drive-thru line, and multiple people had actually tried to wake her up by knocking on her window. At some point, Chester Burton struck the rear of a truck, which was pushed into the rear of another vehicle. She then exited the parking lot, where she ultimately hit the pole. The officers, immediately upon contact, smelled an odor of an unknown alcoholic beverage coming from the mayor's breath, and after speaking with her, she admitted that she maybe have had a couple of apple martinis, first at maybe 5 p.m., and then maybe some more, possibly about 9 p.m. Miss Chester Burton failed the field sobriety tests, and Miss Burton, if you watch Crime Talk, you know, don't take those voluntary roadside maneuvers. Needless to say, not successful in passing those tests, she was ultimately arrested and booked into the Louisville Metro Correction Center, where she was released. She has an arraignment this Friday at 1. We'll see how that goes for her and follow up next week. Next on the docket, our dumb criminal contestant of the day. Jeffrey Trent apparently walked into a beauty salon asking if there was some way to cure his baldness. Mr. Trent was told that there is no magic pill that they could do, nor that they had. Mr. Trent became somewhat belligerent and created a disturbance inside the building. The police were called, and he was arrested on a misdemeanor disorderly conduct. Now, Mr. Trent obviously appears bald in his booking photo, but hey, Mr. Trent, it's called nature. It is what it is. I guess you just need to embrace it and move along. All right, Mr. Trent, you are a dumb criminal contestant of the day, and if you are a dumb criminal contestant of the week, which I will recap the other contestants, you will receive a true Crime Talk mug for your use and pleasure. Maybe you can use it as a shaving mug, by dipping the shaving cream in there to make sure your head is nice and clean and well shaven. Now, a recap. First, Monday, Frank Hebert. He was the man that was stealing the Star Wars memorabilia. It was all on videotape. He came in through the roof and walked out through the front door pushing a cart. Now, this is going to be some tough competition, but then we had Joseph Lancaster, who was drunk and belligerent and was being arrested, and he told the police officers, "I love being restrained. Will you touch my nipples?" Tough competition, because then we move on to Mr. Kijek, who was so drunk and was trying to leave the bar and kicked out of the Uber that he started dancing and said, "You white motherfuckers, I am Rick James, bitch." Have to say, Mr. Kijek may be a leader for sure. Then we had Mr. Dvorak, who punched an umpire because he did not like the call at an adult men's softball league. And then, like we said today, we have Mr. Trent, who simply thinks that there should be a magic cure for male pattern baldness. Please leave us a comment below. Let me know what you think as far as who should be crowned the dumb criminal contestant of the week. We will tally the votes and let you know on Monday. Thanks for watching Crime Talk. Have a wonderful day.